police, and I wanted to ask you just a follow-up question or two about that. There was a lot of testimony yesterday about racial comments or alleged racial comments that were made during this party. Did you ever get any information that your client ever made any racial comments of any nature during this party?
Yes. He did not make any racial comments. In fact, I think it's fair to say from reading the evidence and the statements of the three co-captains that were referenced yesterday that there was probably only one person who made any kind of racial comment, and that comment was made well after both Crystal Mangum and Kim Pittman had left the residence. It was a comment that I believe was reported by one witness who lived next door to 610 North Buchanan, and I think it was uttered in response to something that Kim Pittman or Kim Roberts had said to one of the young men who I think had assembled on the East Campus wall outside of 610 North Buchanan, again, I think shortly before Kim Pittman called 911 at about 12:52 a.m.
And was that comment made by either of the other two people who were ultimately indicted, Mr. Finnerty or Mr. Seligman?
No. In fact, there were no comments, no racial comments, no racial epithets, anything along those lines, uttered at all inside of 610 North Buchanan while Crystal Mangum and Kim Pittman were in there.
And the email that there was testimony about yesterday, did that have anything to do with, or was that from either Mr. Evans, Mr. Finnerty, or Mr. Seligman?
The email that was written by Ryan McFadden?
Yes. It was by somebody other than those three, is that right?
Yeah, it was written by somebody completely different than the people who ended up being charged in this case.
All right, thank you. We were talking at the very end of yesterday's testimony, hearing about the letter that you had written, or Mr. Cheshire had sent on March 30th, 2006,
Yes.
Exhibit 205 in the notebook. And we watched a video clip in which Mr. Cheshire and Mr. Nifong were interviewed by RAL.
Yes.
I want to ask you to go back to Exhibit 205 on the third, it's the second page of the letter, the third page of the exhibit.
Yes.
And can you read the second to last paragraph there, please?
Sure. Moreover, if your office, and this is referring to Mr. Nifong, if your office does eventually decide to charge my client with something, anything, your reported comments make it difficult for me to see how he can get a fair a fair hearing as to the facts of this case in a prosecution by your office in your office's jurisdiction. In the meantime, the inflammatory public comments attributed to you have forced these young men's representatives, including me, to respond publicly in order to effectively defend our presumed innocent clients. Sadly and unfortunately, that has created an atmosphere of trying these matters in the media rather than a court of law, and that could have and should have been avoided.
Thank you. Are you aware whether Mr. Nifong's public comments to the press in this matter continued after April 3rd of 2006?
Yes.
After this letter, the March 30th, 2006 letter,
you're aware of whether they did. What is the answer to whether they did in fact continue after that?
Yes, they continued well after April the 3rd.
All right, thank you.
After this March 30th, 2006 letter, did your office write another letter to Mr. Nifong?
We wrote several more letters to Mr. Nifong.
If you'll look at Exhibit 205A in your notebook, see if you recognize that.
Yes.
And what was the purpose of this letter that Mr. Cheshire sent to Mr. Nifong?
This letter was in follow-up to the non-testimonial identification procedures that we've heard about, or the panel's heard about in these hearings. Non-testimonial identification procedures under our Criminal Procedure Act are treated differently as it relates to what the standards are for obtaining evidence and what the responsibilities of the state of North Carolina are is to providing that evidence to people who are the subject of those procedures. The non-testimonial identification laws require the disclosure immediately upon receipt of any reports of the analysis of any evidence that's obtained pursuant to those procedures. This is a letter that Mr. Cheshire wrote to Mr. Nifong on April the 5th, essentially asking him to provide us as Dave Evans' representatives, because Dave was one of the subjects of those procedures, to all the information to which we were entitled regarding any analysis of the evidence obtained pursuant to those procedures.
All right. And could you read just the last unnumbered paragraph there in that letter?
Certainly. Section 15A-282 of the North Carolina General Statutes requires you to provide, quote, the subject of non-testimonial identification procedures or his attorney with a copy of any reports of test results as soon as the reports are available, end quote. Please consider this letter as a formal written request under 15A-282 to provide me with all such reports and test results related to the materials obtained from Mr. Evans as soon as they are available, including but not limited to the following. Number one, or did you want me to?
Well, let me ask you that. And below that, Mr. Cheshire required photographs of potential injuries, for any kind of photographs of lineups and DNA swabbings, the test results from those. Is that
Yes.
right? Do you know whether other lawyers or other of the, at this point, uncharged players sent similar letters to Mr. Nifong?
Yes.
Can you look at Exhibit 206?
Yes.
And do you recognize that letter?
Yes.
Tell us what it is, please.
This is a letter from Bob Ekstrand, Robert C. Ekstrand, who is a attorney in Durham, who ended up representing a significant number of the players, the lacrosse players, who are also subject to the non-testimonial identification procedures. And this letter is a similar request by him dated April 6th, the day after Mr. Cheshire's letter, generally requesting the same information from Mr. Nifong.
Okay. And on the third page of that letter, does Mr. Ekstrand list out a number of people that he was representing at the time?
Yes, sir.
And are any of those people ones that were ultimately indicted in this case?
No.
Can you, on the second page of Mr. Ekstrand's letter, can you read paragraph 3 and then the last paragraph of his letter?
Certainly. Paragraph 3 states, regarding the DNA swabbings, the results of any analysis made to compare with any of my client's DNA with any other material. To the extent that any test results, including any preliminary or partial test results, are already available, please provide me with a copy of any such reports in the same manner.
Did you, or to your knowledge, any other defense counsel ever receive any preliminary or partial test results from the NTO from Mr. Nifong other than the written reports?
No.
Did you send another letter to Mr. Nifong about this matter shortly after Mr. Ekstrand's letter?
Yes.
Can you take a look at Exhibit 208, please?
Okay.
Identify that.
This is a letter that Mr. Cheshire wrote to Mr. Nifong on April the 7th, 2006.
And what was the general purpose of this letter?
The general gist is that we had heard, well, and seen on television, comments that led us to believe that there was information that the state had obtained regarding some of the testing that was the information that was out there, and we were essentially following up on what we had requested before, and also asking if Mr. Nifong would be willing to meet with either our client Dave Evans or Mr. Cheshire or both of us to talk about anything that he wanted to talk about or his investigators wanted to talk about regarding that night.